Hi friends, my name is Stalvin Jojo. I am first year M.Com student of St. Thomas Autonomous College, Thrissur. Welcome all of you to my presentation, and today we are going to discuss about National Green Tribunal, strength and weaknesses. So let me give a brief introduction about National Green Tribunal. It is a specialized body set up under National Green Tribunal Act 2010 for effective and expeditious disposal of cases relating to environmental protection and conservation of forest and other natural resources. So from this definition, it is very clear that the sole aim of National Green Tribunal is to conserve nature for future generations. So let us go through the strengths of National Green Tribunal. The first one is NGT can pass strict orders related to environment sensitive issues. Over the years, NGT has emerged as a critical player in environmental regulation, passing strict orders on issues ranging from pollution to deforestation to waste management. And the second point is it acts as an alternative dispute resolution mechanism. NGT offers a path for the evolution of environmental jurisprudence by setting up an alternative dispute resolution mechanism. This has made dispute mechanism so much easy and customer friendly. And the third point is it helps in reducing the burden of litigation of high courts on environmental matters. Nowadays, it is quite evident that high courts are indulging or involving in many environmental related cases. By NGT, National Green Tribunal, the litigation of high courts on environmental matters can be reduced to some extent. And the fourth point is LGT is less formal, less expensive, and faster way of resolving environmental related issues. So this offers a wide range of possibility for new enterprises concerning environmental matters. NGT is less formal, less expensive, and faster way of resolving environment. By these features, NGT is providing a more customer-friendly approach. And the fifth point is it plays a crucial role in curbing environmental damaging activities. The main objective of National Green Tribunal is to protect nature for future generations. So it plays a crucial role in curbing environmental damaging activities. And the sixth point is NGT helps in independent decision making. As the chairperson and members are not eligible for reappointment, hence they are likely to deliver judgments independently without succumbing to pressure from any quarter. And the seventh point is NGTs ensure that environment impact assessment process is strictly observed. The NGT has been instrumental in ensuring that environmental impact assessment process is strictly observed. The importance of environmental impact assessment is quite significant nowadays, especially for Kerala, because there are increasing instances of natural calamities in Kerala in the present days. So the significance for environmental impact assessment is increasing day by day. So these are the strengths of NGT. It can pass strict orders. It acts as an alternative dispute resolution mechanism. It helps in reducing burden of litigation of high courts in environmental matters. It is less formal, less expensive, and faster way of resolving environment related issues. It plays a crucial role in curbing environment damaging activities. It helps in independent decision making. It ensures that environment impact assessment is observing properly. Even though National Green Tribunal is having a number of strengths, it is also facing numerous challenges. The first one is two important acts, Wildlife Protection Act 1972 and Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006 has been kept out of NGT's jurisdiction. This restricts the jurisdiction area of National Green Tribunal and at times it hampers its functioning as crucial forest rights issue is linked directly to environment. So from this point, it is quite evident that some important acts or some important laws related to forest protection and wildlife protection is ignored while considering National Green Tribunal matters. So this restricts the jurisdiction area of NGT and at times it will further affect the functioning of NGT. And the second point is NGT decisions are being challenged in various high courts under Article 226, with many asserting the superiority of a high court over the NGT, claiming high court is a constitutional body while NGT is a statutory body. This is one of the weaknesses of the Act as there is lack of clarity about what kind of decisions can be challenged, even though according to the NGT Act, its decision can be challenged before the Supreme Court. So, the another challenge faced by NGT is the challenge from high courts. The decisions of National Green Tribunal can be challenged by High Court or even Supreme Court. The third point is decisions of National Green Tribunal have also been criticized and challenged due to their repercussions on economic growth and development. So, some of the NGT norms and policies are against economic growth and development policies of the government. So, it is considered as a huge criticism related to National Green Tribunal. And the fourth point is the absence of a formula-based mechanism in determining the compensation has also brought criticism to the tribunal. So there is no particular formula for determining the compensation. This is making the job quite difficult for National Green Tribunal members to decide what compensation to pay to whom. And the fifth point is the decisions given by National Green Tribunal are not fully compelled by stakeholders or the government. Sometimes its decisions are pointed out not to be feasible to implement within a given time frame. So, non-compliance of regulations formulated by National Green Tribunal is another important challenge faced by NGT. And even government is criticizing NGT that most of the decisions brought forward by NGT is not economically and politically feasible. And the sixth point is the lack of human and financial resources has led to high pendency of cases. This is one of the huge drawback or huge challenge faced by National Green Tribunal. Even though India is rich with huge amount of human resources, the human resources available for National Green Tribunal is limited, and also financial resources allotted by government to National Green Tribunal is comparatively low compared to other departments. And the seventh and last point is that the justice delivery mechanism is also hindered by limited number of regional benches. So there are very limited regional branches for National Green Tribunal. As a result, the delivery mechanism of justice is hindered or blocked due to lack of regional benches or regional support. Next, we are going to discuss about Consumer Protection Act 1986. Let me give a brief introduction about what Consumer Protection Act means. The Consumer Protection Act was passed in 1986 and it came into force from 1st July 1987. The main objectives of the Act are to provide better and all-round protection to consumers and effective safeguards against different types of exploitation such as defective goods, deficient services and unfair trade practices. It also makes provisions for simple, speedy and inexpensive machinery for redressal of consumers' grievances. So from this definition, it is very clear that Consumer Protection Act came into existence to protect the interest of consumers and to avoid or reduce exploitation of consumers by businessmen nowadays. And let us go through the salient features of Consumer Protection Act. And the first one is it applies to all goods, services and unfair trade practices unless specifically exempted by central government. So it is applicable for all goods and services other than goods and services specifically exempted by central government. And the second point is it covers all sectors, private, public or cooperative. And third point is it provides for establishment of consumer protection councils at central, state and district levels to promote and protect the rights of consumers, and three-tier quasi-judicial machinery to deal with consumers' grievances and disputes. So one of the major aim of or one of the major features of Consumer Protection Act is it tries to establish or tries to make consumer protection councils at central, state and district levels. This would be a great help for consumers for their grievance redressal. And the fourth point is it provides a statutory recognition to 6 rights of consumers. So it provides statutory recognition for 6 consumer rights. And finally, we are going to discuss about the objectives of Consumer Protection Act 1986. And the first objective is better protection of interest of consumer. The Act seeks to provide for better protection for the interest of consumers, and for that purpose, it makes provisions for establishment of consumer councils and other authorities for the settlement of consumer disputed and for matter connected therewith. So one of the major objectives of Consumer Protection Act is to better protection of interest of the consumer. And the second one is protection of rights of consumers. The Act is intended to protect the following rights of the consumers. The first right is the right to be protected against marketing of goods and services which are hazardous to life and property. The right to be informed about quality, quantity, potency, purity, standard and price of goods or services as the case may be, so as to protect the consumer against unfair trade practices. Likewise, there are a number of consumer rights. So one of the objectives of Consumer Protection Act is to protect these rights of consumers. And the third objective is consumer protection councils. As we mentioned earlier, the above objectives are sought to be promoted and protected by consumer protection councils established at central and state levels. And the fourth one is quasi-judicial machinery for speedy redressal of consumer disputes. This Act seeks to provide speedy and simple redressal to consumer disputes. For this purpose, there has been set up the quasi-judicial machinery at the district, state and central level. These quasi-judicial bodies are supposed to observe the principles of natural justice and are empowered. And it is to give relief of a specific nature and to award wherever appropriate compensation to consumers. So it provides a systematic redressal mechanism for consumers. So these are the 4 objectives of Consumer Protection Act. So that's my presentation. Thank you for your constant listening.